Thank you, Mr. Speaker. Mr. President, I beg your pardon. Mr. President, I could stand to speak at length because it is an area that I am very passionate about, but I am going to opt instead to be brief. And may I be permitted just to say a few words in my response. One of the points that was made by Senator Lachmidial that I'm reluctant to, but I will respond to, is the suggestion, or the submission rather, that there is still a preference for the system that existed in preliminary inquiries where you need to test the evidence. Well, the short point in answer to that is that the evidence of a fair trial is going to be tested. Let's just think about what we are doing under a JIPA. Under a JIPA, someone is charged, and the documentation which provides the master with the evidence on the basis of which the charge was brought is brought before the master in documentary form. And there is going to be no cross-examination. You have to trust to your judges to apply the law, to be dispassionate, to be fair. The master is going to look at that documentary evidence and come to a determination of whether or not there a prima facie case has been made out. Prima facie meaning whether there is sufficient credible evidence that persuades the master that on the offense charged, this person should face a trial at the assizes. Under the old system, we spent 6 to 10 years cross-examining all of the witnesses on that before the magistrate could commit to the assizes. And what suffered in that process was exactly the point that Senator Murad speaks to. The entire system got clogged. What suffered under that are the accused, the victim, the families, and the communities, because the process was never ending. Under a JIPA, the documentary evidence is assessed by the master. The master says no sufficient prima facie case, and that's the end of it. The case is thrown out. Or, as we saw in the case of the Sheldon Dooth matter that I spoke to, within a matter of 4 months, instead of 6 to 8 years, the master says there is a sufficient prima facie case made out. And what is the next step? The next step, Mr. President, is a trial. And at that trial that takes place within a shortened run-up to the wicket, that accused will get the full benefit of a fair trial. His lawyer will be able to cross-examine before the judge all of the witnesses who seek to put him behind bars, and the case will either stand or fall on the veracity of the material evidence that is brought before the judge. So there is no compromise of the fair trial right in the process that a JIPA now brings to the fore. What is brought to the fore is that the accused is going to know in a shorter period of time whether he is going to spend his time behind bars or whether she or he is going to walk a free woman or a free man. What is wrong with that? A number of other points were made, Mr. President. Senator Lachmidial takes credit for the fact that 2011 Act was the opposition's vision. Well, the 2011 Act was the opposition's vision. You know what came out of the 2011 Act? Section 34.
Yes, it's true, it's true, it's true.
What came out of the 2011 JIPA Act that the People's Partnership brought before the Parliament is that in the dead of night, one night when everybody was on holiday, they came back to Parliament with Section 34 to get their friends out of jail.
Sneaky, sneaky, sneaky.
For that vision, Thank you very much, Mr. President. Thank you very much, Mr. President. So I could spend much time. Senator Lachmedial also makes the point that there are staff constraints at the office of the DPP and other places. Well, the fact of the matter is that my office is hard at work actively seeking to fill vacancies at the office of the DPP. Yeah. Last year, we offered to bring, I wrote to the Commonwealth Secretariat, to Baroness Scotland. I got her agreement to engage with me, and I engaged with the DPP to bring Commonwealth lawyers to Trinidad to stop the DPP. The DPP said, no, thank you. We are now in the process of filling vacancies on short-term contracts. The Judicial and Legal Service is in the process of doing that. As we speak, vacancies are being filled. And as we speak, and I said this in another place, as we speak, there is a building that is being sourced so that the DPP will have a building to move into and to give him the spatial requirements that he needs. And at his request, we are currently making provision for IT facilities for the DPP. So we can't, with every innovation, we can't stop and say, well, we have problems, so let us not initiate the innovation because the problems are too much for us to bear. We have to move on. A JIPA is in place, and we are putting the systems in place. And therefore, I don't accept the criticisms that there is not sufficient resources or not sufficient will on the part of this government to work with all stakeholders to enable the judicial system, the administration of justice, to move forward. Mr. President, Senator Maraj asks rhetorically, she hopes that this case, the Dudnath case, is not the exception. Well, let's look at life positively. This is one of the first cases that has come to court since a JIPA, which was passed in 2023, December 2023. The case was committed, was assigned, man was charged in January 2024. Let us take that as a signal of an optimistic passage into the future that we can do better. Yes. Why must we decry the first case that comes to trial and is demonstrably being managed in a better system that has been produced by a JIPA, as well an exception which we are not going to continue with? We must be positive. If we are going to move this nation forward, we must be positive.
AG, can I
Sorry,
can I ask
beg
a
your
question?
pardon, my back was to you, Senator.
I probably don't understand whether now that a JIPA is passed, does it include those, how many thousands of cases that were there before a JIPA was passed, and those cases that are waiting that long, will that affect those cases? Because I think that's one of the big questions.
To answer your question very briefly, Senator, in principle, yes, what is going to happen and what is happening under a JIPA is that the old cases that existed before will be brought before the master, and the master will do an assessment as to which can move forward and which have to remain in the old system. It's an ongoing process, and I know that from the information I have, and there is a unit within the Office of the Attorney General called the Criminal Justice Unit, and we work every day with the judiciary and every day with the police and the DPP's office. It is a moving target of achievement that we are committed to in collaboration with other arms of the state to make the system work. So the answer to your question, in principle, yes, but it will take some time because each case is going to have to be looked at on its merits. Thank you. Mr. Speaker, Mr. President, I beg your pardon. I was going to move next to touch very briefly on the question that had been made by Senator Lachmedial Would persons giving witness statements be familiar with the procedure? Given statements should not be able to be put into evidence. Well, training and sensitization on a JIPA has been in place and is being conducted by the judiciary in collaboration with the Criminal Justice Unit of the Office of the Attorney General since 2023, prior even to the proclamation of a JIPA. And all of the stakeholders are engaged. All, the police service, the prison service, the Office of the Director of Public Prosecutions, the public defenders who are part of the Legal Aid Authority, and it is an ongoing process. Mr. President, I could continue in detail, but I don't think that, I think I would overstay my welcome in speaking too much. So with those few words, I beg to move.
Ooh, great.